in this instance, if everybody's here, we could range from huge to pre-finance, so it's going to be a big range. And, well, okay, let's just start with that. So, who here has experience with patents? Okay, and has anybody been involved in a proceeding, like a litigation or something like that? Or something before the patent office? Okay, so not that far. Who here has been involved in drafting a patent application in some kind of way? Is it most people? No? Okay. And who here hasn't seen a patent before? Maybe. Yeah, okay. So yeah, just so you have a little bit more to picture, I don't know who wants, or there's nothing special about this particular patent. It just, pass them around. Yeah. Just so you have something to look at as we're talking.
You got one. You've been down there before.
And then what technologies do folks come from? I get the idea we're generally a tech group. We're not bio, we're not pharma. Is there anybody wrong? Anybody more chemically oriented? No, okay, so we're more tech, mechanical, okay, which is good. So my personal background is, my formal tech training is electrical engineering and optics. I worked initially in Boston for a few law firms there, and then I came to work in-house at Bausch & Lomb here, where I did a lot more mechanical work and medical device work. So my practices span pretty much everything other than the more chemical things, pharma, chemical, material science, that's outside of what I do personally. And so as we go through here, the one thing I want to suggest is really think about your predicament, think about moving forward, but also think about people you're going to end up dealing with along the way in working in your business. Think about how they're going to view this too, and I think it can really give you some insight and make this as useful as possible. Next, let's make it interactive, okay? Ask me questions at any point, jump in. I have about 20 slides in about 100 minutes, so we're going to want to go through about 5 slides a minute. But let's make it interactive. Of course, everybody should keep their confidential information confidential. And I'll have, of course, things to share with you guys. And needless to say, nothing I say is legal advice. And the way the flow of the talk will go is initially we're going to do some intro work. Oftentimes people kind of get a misunderstanding of very basic ideas of patents, and it kind of skews the rest of it. So what I do is I work up kind of from a foundation. It's going to be a review for some of you, but perhaps it'll give you some insights, even if it's something you thought you knew, as far as forming a base for the rest of the talk. And it would also make sure that folks who haven't had as much experience with patents will get up to a certain level before we talk. So today the focus is more on acquisition of rights, and I'd say the focus is more internal, and then the second talk is going to be broader scope and talk about interacting with folks outside of your organization more. All right, so let's go ahead and get started. So, general rule, of course, is in our economy is free and open competition. The best product wins, best service, best combination of products and services wins. But the people have competitive advantages, of course, in the form of intellectual capital. And it's everything your company knows that gives it a competitive advantage. Right? It's a pretty broad definition, and an accountant could give you a more strict definition. And then there's a certain portion of intellectual capital which is legally protectable, right? So the exceptions to free and open competition would be intellectual property. And what that provides is a legal right to exclude others. And we're going to talk a bit more about that, but that's the mindset you want to have. A patent, an IP, is a right to keep others from doing what is your IP. And we're going to make a distinction there in just a second. So to work with IP takes time, takes effort, takes dollars. So you really have to form a strategy and form an understanding and a budget and all those kind of things. and budget your time as much as your money, because it does take people away from the core of their business. But again, it provides competitive advantage. So as you're doing that, you need to bear in mind, and we'll see through the rest of the slides, precautions are needed to acquire and preserve rights, and there's concerns about timing, and there's concerns about commingling your IP with somebody else and maybe unwittingly making somebody else a co-owner with your rights. So those are things you want to be careful of. And then, as I say, you need a filing strategy, you need a budget. You need to think these things through to really get your money's worth. Yes?
A question on larger firms. Have you seen any good practices where people have kind of policies to keep things quiet? A quick example, way back when I worked at Procter & Gamble, and they had an in-house rule in the food engineering division. They had an in-house rule, nobody talks about their job away from their desk. And I thought that was tremendous relative to just a very simple rule to keep things quiet. Because I worked in food engineering while they were developing, long ago enough, developing Pringles. Those engineers I worked with were doing it, I never knew it.
Yeah.
So have you seen any good, simple guidelines that firms use that help with that precaution part?
I have not seen anything formally written, but certainly, discussed among the group, and mostly at the individual project level is what I see.
Yep.
Having a policy makes sense, and it's a good idea. And our talk today is mostly going to be about patents, but we're also going to touch on trade secrets, and we'll get into there. You'll see some policy level ideas that come out.
Good.
So the goal today is learning to identify issues, and then also learning a framework for making decisions, right? That's what I hope everybody will focus on, and that's how we'll make the best use of your time. And of course, some IP savvy. And what I mean by IP savvy, we'll of course get into it later, is there's the hardcore law that goes along with it. There's a lot of practicality that really bears on the value of IP, and understanding its true value takes understanding some of the not so legalistic ideas. So, all right, so IP is that portion of intellectual capital that's legally protectable, and you can exclude others. So there's 4 primary types of IP, and they have, of course, very different scopes, take different amounts of effort to acquire, and they have different durations, right? So with trademarks, and it's not my intention to make these the focus by any means, but with trademarks, the standard is confusion. A little bit strange, right? I mean, you're looking at ordinary consumers, and are they confused by one trademark with, are they going to confuse one with another, such that the source of whatever product it is that's of interest is going to be in question. Am I buying this from the same company I was buying it? That's what trademarks are aimed at. Duration is indefinite. Registration, you may or may not. There is a common law form of trademarks, so you may or may not need registration. Copyrights. Copyright protects exactly that, copying, right? There needs to be some form of copying. Duration is quite long, right? It's life of the author plus, I think, 90 years now. So they've kept expanding that. I think people would say largely because of Disney and Mickey Mouse. And then the 2 primary topics today are patents, and utility patents in particular, although we'll touch on design patents. And so with patents, there's absolute protection. I don't care whether you're copying what I'm doing. I don't care if you knew about it. Stop it. It's your job to get out there and find out about it. Actual knowledge has some bearing on things like damages, but to enforce a patent, there is no knowledge requirement. You can get an injunction. And then trade secrets. So those 2 play against one another, and we'll get into that a bit, right? Trade secrets, they protect against illegal disclosure, right? So that's different. People can independently develop an idea, and trade secrets won't help you. Trade secrets can last indefinitely. Different organizations can hold the same trade secret. Is registration necessary? No. This is where we get into this idea, and we'll get further into it, of having a policy regarding who has the information and how is it disclosed and how is it protected.
Can you give an example of trade secret, versus patent? And I understand it's patent, but what would a trade secret?
Yeah, it's kind of strange, isn't it? Well, one example, the classic example, is the recipe for Coke,
Okay.
right? Not patented, very old.
Could it have been patented?
Initially, well, I suppose you have to go back in time to specifically when that
Yeah,
possibly happened.
But say it was today.
Just a recipe, no, you wouldn't get a patent on it. And so you don't register it, you don't do anything. It's more a matter of how you treat the idea. And as I say, I mean, it's kind of a strange thing for people to get their arms around, but it is intellectual property. It's enforceable in a court. One of the first
But
things.
it's not registered, how is it protected in a court?
First, you have to establish that you have a trade secret, and what does that mean? You treated it like a trade secret. You kept it secret. You kept it limited knowledge, even within the organization.
Yeah.
It's got to be protected. One of the problems, and we will get to this more later, but one of the problems with trade secret is people don't have a policy, and it tends to be used colloquially.
Yeah.
That's our trade secret. Is it? I mean, there are specific requirements, and when you go to enforce a trade secret, the first thing the court does is establish whether you indeed have a trade secret.
Yeah.
How did you treat the information? Even to the point of you want to say something's your trade secret, but people were working on a bench within your organization in the open where everybody could see it, and not only that, you've had people walking through for plant tours or in your organization, so you're not treating this as a trade secret, forget it.
Yeah.
But it's, people would sign non-disclosure agreements, that would be another thing you'd look to, right? And so, I mean, trade secret's kind of a weird thing, and people have trouble gathering what exactly it is, but it's actually the unpatent, right? Because patent, I mean, even the word itself means open. And what the government's looking for with a patent is, you give up your information, right? I mean, we'll get more into this, and we give you exclusive rights for a limited amount of time. Whereas a trade secret's the opposite, right? It's like, nobody knows, and that's where the protection is. Until it becomes generally known to the public, it can be a trade secret. And as I say, two different companies could have the same trade secret, so long as it's limited. Who has that information out there? But we will get back into it. So, as I say, our focus is going to be patents and trade secrets.
So before you shift your focus, with copyrights, is it really applicable besides anything of artistic work, written documents,
Software would be the big one.
software?
And at various times, like back in the 70s, people didn't think software was protectable. I mean, the courts said software wasn't protectable. And you have to think back, and software has gone back and forth as far as no rights, absolute rights, not so much. And we'll, again, get more into that in a little bit, that in the last 5 years, there's been the Supreme Court got involved in the issue and kind of muddied the waters, and it's finally being resolved again. But yeah, copyrights and software is the big one.
Okay.
So, a patent, what is a patent? What's in a patent? You have the front page, so everybody should have a copy of a patent now, right? So, on the front page, you have a bunch of bibliographic information. The one thing to know, that most everything in that document was generated by the inventor and their attorney, right? Except for what the bibliographic information on the front page. The heart of a patent is the claims, right? The claims, and that's the back. If you flip all the way to the back, you'll see the claims. And the best way to think of claims is it's like a deed for real property for your house, where you have survey information defining the scope of what it is that you own. Here it's the words. And in particular, you want to notice that in the claims, there's independent claims, there's dependent claims. I should have, that's it coming. So if you look at this patent, there are They're numbered. You can see there are 16 total claims. And there is one, what you call independent claim. Everybody familiar with the concept of independent claim, or not so much? Yeah, okay. So, the first claim is what's called an independent claim. It doesn't reference any other claim. It's the claim, independent claims are the claims that have the broadest scope. They have the least, and this again is something that people get hung up on, it has the least amount of specificity. With a claim, generally, it's more valuable if you have less words and less specificity in it, right? Because in order to infringe a claim, in order to have a right against somebody for using your invention, that somebody has to be using every element of what's in at least one of your claims, right? And so because an independent claim has less specificity, the dependent claims, say claim 2, incorporates everything that's in claim 1 plus something more. So claim 1 in this instance is the independent claim. It's the broadest claim. It has the least amount of specificity. It's easiest for somebody out there to do everything that's in that claim and therefore infringe your patent. So, that is claims are the heart of any patent application. Those words are all considered, should all be considered carefully, each word, and things like prepositions matter, in and on, and what does that mean, and until you really get into an instance of reviewing these things and looking at what those words might mean and what in and on, does it mean sitting right on, or can it somehow have a boundary around it that you're within, yes.
If a person's just starting, say their first patent, just starting into this, and they get into this independent claims and dependent claims, where should they start looking as to what that means before they start talking to a patent attorney? Or
Yeah, that's a good question.
do they Google it and find out?
The individual words?
Yeah.
Yeah. Well,
Yeah,
I think
different.
initially you just read it, right? Claims are understood as one of ordinary skill in the art would understand them, right? That's a legal
Okay.
term.
Okay.
And that's what the court's going to decide. Now, they're going to be given these terms are going to be given their ordinary meaning within the technology that we're talking about, right? And there's going to be some understanding of how somebody in that particular art would understand it. But also, you have to be mindful of, in the rest of the specification, whether they've given some particular definition, right?
Okay.
It's, you may find some particular definition there. It's laid out, it could be implied, it could be stated definitely, definitively. So, claims could be method claims, yes.
Just to clarify one, that's that skilled in the art or whatever.
Right. One word
With
is
the
here.
breadth of technologies we have these days,
Right.
how do you define that?
That's what the courts are all about. Yeah, I mean, there is no,
Okay.
it's tough. I mean, we'll
Yeah.
get even more into that, even, I've been practicing for 20 years. Ultimately, what I'm trying to do is I'm trying to interpret what a court and a jury would decide, right, when I look at it. Take that for what it's worth, right? I mean, as we all know, judges and juries make decisions that you go, really? And then you go to an appeals court and you get a different decision. So, and sometimes the funny thing is, right, sometimes the ultimate decision that gets made by whatever court, you've had more judges say the opposite, come to the opposite conclusion than the final, than the final decision. So
if you were in litigation, you'd have to go out and find yourself somebody skilled in the art, and that's your opinion as to whether they're skilled or not.
well, even that, I mean, it's a legal construct. It's not one person, right? But that's kind of that's one of the purposes of, say, a expert witness.
Okay.
Right? I mean, the judge is going to look to them as
Yep.
being that, but then both sides are going to have experts. One's going to say one thing and one's going to say the other,
Okay.
right? So, yeah, that's the way that all works out. So independent claims, dependent claims, we talked about that. So the game with the claims, of course, is you file a patent application. The examiner is going to tell you why you're not entitled to a patent maybe cite art against you saying, no, you're either obvious or you're not novel over some form of prior art, and you're gonna have to somehow establish that you're distinct from that. So you're gonna have to have enough words in your claim to distinguish what's out there, just in terms of prior art. But again, you don't want to narrow things too much, because you narrow things too much, it just makes it less likely when you actually have the patent out there that somebody's going to infringe your idea, infringe your claim, right? The more specificity, yeah, it makes it easier to get through the patent office, but ultimately what you're holding ends up being a narrower piece of property than maybe you should have had, let's say it that way. So, claims are the heart, but as we were talking early on, in exchange for getting a patent, governments are looking for openness. They're looking for you teaching people, teaching the public. That's the whole idea, is patents are supposed to advance the art, in long term. Sure, it provides a monopoly over the short term, but it gets education out there, it gets information out there that people then build on. So you have the claim, and the rest of the document, which is 90% and sometimes well more than that, of the text is not claims, and that 90% is all about teaching people how to make and use their claimed invention, right?
So the key piece is that last page.
Yeah, right. I mean, that's it. But you have an obligation, and the trade-off is teaching people how to make and use the invention.
Yeah.
And that's where you get this trade-off. Again, we'll get more into it in a bit, between trade secrets and patents. When you decide to file for, file a patent application, you need to make a decision. You're willing to put that information out there, realizing you might not get a patent, or you might not get the patent you want, right? But you've put the information out there. And it used to be in the United States until the late 90s. Patent applications in the United States didn't become public until there was an issued patent. But now they publish after 18 months, which is usually before you get any kind of examination. The information's out there before you've heard an examiner take a side on whether it's patentable or what might be patentable.
Is that what pending means?
Pending, yeah. Up until issue. Okay. So the other thing with an application is you need completeness, because, as I said, everything in that patent, excluding the first page, was generated by the inventor and the attorney. That doesn't change during the course of the examination. I mean, the examiner might tell you you're not entitled to a patent, and you can change your claims and say, no, we're different because this. And he'll say no, and you, or she, and you'll make a decision. You think they're right or wrong. If you think they're wrong, you just argue with them. You don't change your claim. But if you think they're right, you change it. But you can only change based on what was in the document at the beginning, right? There's no adding information, so completeness is important.
Is there a hierarchy of courts like there is in, criminal law?
Oh, yeah. We'll get into that again a bit, but you've got trial level courts, right, which run trials and take in evidence, and then everybody above that is an appeals court, and they're just ruling on law. Right, they're not retaking in evidence. They might consider whether the evidence met a certain standard, but they're not taking in new. And they'd say, we didn't look the witnesses in the eye. We don't know how much weight you put on them. We just need to know that you justified your answer. And then, so in patents, to give a little bit of a civics background, right? You've got the district court, trial courts all over the country. Then, if it's a patent matter and it gets appealed to what's called the CAFC, the Court of Appeal for the Federal Circuit. And they're the court that's primarily the patent court. It's a patent issue. You don't go geographically like you do for criminal or other areas of law. If it's patents, it goes to the CAFC in DC, and they become the primary court, except when the Supreme Court decides to get involved. And again, we'll get into that. So that's the way that goes. And then, I'll mention this so long as we've already headed down this route. The Patent Office. Patent Office is actually in the executive branch under the Commerce Department, right? So you've got the courts ruling, but you've got the executive branch that's responsible for examining patents and deciding what the standards are. And there's some really interesting particular examples of this, and we'll get into it. The Patent Office, in deciding whether to grant a patent, has to interpret those laws, has to have some idea of the court cases that have been had out there that interpret the actual laws of Congress. And it has, they're using those to form the standards for what's patentable. And with software, there's a very, very important point to be made there. We'll get to that. So, what rights does a patent give you? As we said, it's a right to exclude others, but a right to exclude others from what? And there they are. Making, using, selling, offering to sell, or importing. Right? So if you do any one of those things, and you meet all the terms of at least one claim, you match all the elements of at least one claim, you infringe and somebody has a right to enforce. Yeah.
The term importing looks a little out of there if we're talking about the United States.
Pardon?
We're talking about US patents.
U.S. patent gives you a right to exclude in the U.S.
What is the term, how does having a patent in the US deal with the term importing?
Crossing the borders into the U.S., so products made in China,
Okay.
Japan, Canada, Mexico,
Can't
can't come over the border,
Okay,
right?
They
And
could,
it's-
it could be out there but they can't come into the US if I
That's
have a
right.
patent on it.
Yep.
Okay.
Again,
Thank you.
we'll talk more about that, but that's the idea. A U.S. patent gives you a right to protect against those things in the United States. If something else is happening out there and never crosses the U.S. border, there's no issue. Importing usually has to do with the ITC, right? International Trade Commission also holds patent, or reuse patents. Let's say. So one very important thing to understand, and I've seen very experienced people in organizations get this wrong. A patent doesn't provide an owner a right to practice the invention, right? It's a right to exclude others from practicing the invention. Everybody comfortable with that?
Can you give an example?
Yeah.
Okay, the simple example is, and sometimes this really twists people's view, and it takes a while to absorb. But the simplest example I give is a pencil. So somebody has a patent on a pencil, a cylinder of wood, for whatever word you want to choose, with a bead of graphite going down it, right? Somebody has that patent. Another person comes along and they get a patent on adding an eraser at the end of a pencil. So, and they put together their patent application for this eraser, they put it to the patent office review is it novel? Well, nobody's put an eraser on the end before. Is it not obvious? Well, there's a bunch of determination that goes into that, but, presumably, it's not obvious, nobody ever thought about doing that before. All right, then you get a patent. So now you have two patents. One on the basic idea of a pencil, and the one on the pencil plus the eraser. Who can practice their invention? I over here, I have the patent on the pencil with the eraser, but if I practice my invention with the wood and the bead, I've done everything that's in his claim.
Yeah.
He's got superseding, or she has superseding rights to mine. I can't practice my invention. Now, they can't practice mine either, and there may be some room for negotiating, and anybody who somehow acquires rights to do what they're doing can't use my eraser without coming to me, but I, and nobody, actually, because I, as the owner of the eraser patent, can't practice the invention either, but I've got a patent. Okay, so I have a patent, but I can't practice it. And, in different contexts, that has different meaning. Sometimes, again, this is a mindset that's common, is, somebody comes up with the basic idea, and they've got a patent on it. But one thing you have to realize with with just patents generally, is most aren't commercially viable, right? Most patents don't see the light of day as a real product.
It's a piece of value that you can sell.
Yeah, well, just no market for it. Nobody figures out a way to make money off it, right? And that's a vast majority
What I mean by that is that somebody else might say, I need that patent in order to do product A.
Yeah.
So I buy the patent from you, even though.
License it, right?
Huh?
Or license it, right?
Yeah, or license it, yeah.
Yeah. But the point I was going to make is, some people think, oh, they got the basic idea, that's the end of the story. There's no more value to be had, like the guy with the eraser. But the fact is, sometimes they just can't figure out how to make this a viable product to make money on it. And it takes some other innovation by somebody that makes it a
Yeah.
commercially viable product. And that person that then has that improvement that does that, they're sitting on valuable, they're sitting on something just as valuable as this underlying idea.
But they've got to get a license or buy the patent from
Right.
that first one in order to get the pencil with the eraser.
That's right. Okay, so I had to do this a few times just to get some concepts in there, just do it aside, so step away from what we were talking about. The important thing to realize, we've touched on this before, is patents aren't black and white, okay? I mean, that's something we're talking, again, this probably falls in the scope of this patent savvy. It's important to realize, sometimes people want to know, well, is it or isn't it? Am I or am I not infringing? Or does this cover their product or doesn't it?
Maybe.
Well, ultimately, we're making a determination about what a judge and a jury would say. And the best thing I can do is I can give you odds. I can tell you have a strong case, I can tell you have a weak case, but I can't tell you for certain what's going to happen when you step inside the courtroom. And so, in the context of an examination, that can come up. You put when you're going to file a patent application, we could be looking at the prior art and looking at the claims and say, this is the interpretation we want to take. We're going to be aggressive here. We're going to try to go as close as we can to this piece of prior art, but we're going to be distinct. The examiner may or may not go along with us. If not, we have to draft this because we need to have everything in the application at the outset. We're going to anticipate that. And this is where the lawyering comes in, and we're going to come up with fallback plans. And the input, this whole thing, it's lawyering, but it's also interactive with the inventors or whoever the technical folks are that are involved in it, right? You need to make some determinations and have some insight as to where this patent application might end up in the process and where the sticking points might be, and try to anticipate them. But you never know where an examiner or an appeals board, and there I'm talking about within the patent office itself, where they're going to fall. Or ultimately, if you're enforcing it, where a judge and a jury are going to fall.
The examiner and the appeals board in the patent office, they're required to explain to you what the problem is.
Right, and they do that to varying degrees, and you have to make a decision. I've got things now in front of me. If you decide to put the examiner's feet to the fire, well, that can be received in different ways.
Okay.
But yes. And ultimately, when you're in the innovation space, you need to learn to become a manager of risk. There's no question you're going to face some kind of risk if you're coming out with a product and you're going to launch the product. And if your expectation is, we're going to get to zero risk, I'm going to launch this product and nobody's going to sue me, you're not going to get there. And if you try, I didn't put the graph in here, whoops. I didn't put the graph in here, but I would ordinarily draw a graph that would say, if you've got risk on the vertical axis, if you've got dollars on the vertical axis and you've got risk on the horizontal axis with 0 and 0 being over here, origin, your graph's going to go, well, it's pretty cheap initially to reduce your risk and do some patent searching and maybe change your product to reduce your risk. But as you try to, you get down to a certain number of patents and you're looking at them closely, the cost of reviewing is going to go up and up and up, and you're really not even going to know you're looking at everything, and you can't necessarily be looking at everything that could potentially cause you risk because, as we said, patents don't even publish for 18 months. So you might not be looking at everything when you get started. And so to try to stamp out every last bit of risk is just a fallacy. It's more a matter of managing risk and trying to decide, and this is more the topic for next week, what are the things that if you ran into trouble that you'd have trouble changing to deal with the issue that's come up. And those are the things you want to focus your effort on. And so, we'll get into it more next week. But the point being, there's risk in many forms here when you get into the space. And I suppose the other thing to touch on is I've worked with clients who, their entire life of their business has been commodity work, let's say, right? It's not proprietary, there's no patents, it's just crank it out efficiently, sell it at some kind of margin. and make money that way, and then they want to go into the innovative space and deal with patents. And it's just a strange, it's a leap, and some people are okay with it and some people aren't. But this is what changes, and suddenly now you're dealing with, well, if I want to make this the best I can, there's other people who've also put in money in R&D and have decided to protect their ideas with patents, and now you're going to encounter them, one way or another. I mean, hopefully you can navigate around them, but you've got to deal with it. And so you end up thinking in terms of probability and thinking, again, contingencies. What happens, what is it that really defines my product and that I couldn't give up? Those are the things I want to focus on. And what is it that if I ran into trouble, I'd redesign it? It might be inconvenient, no doubt, and I'd prefer not to have an issue, but I can deal with it better. Okay, so an overview of the patenting process. Invention, identification, search, drafting, pen hits paper, and then filing in the United States, but then also around the world, right? So there's I would say 4 primary things you'll encounter. The first 2 you'll see I put the arrow back and forth. There can be iteration there, right? It depends how somebody, say, comes to me or to a patent attorney, what those first steps look like, how concrete and how well defined is what it is that you think is your invention. Sometimes it's come to me thinking, well, the algorithm and how we do this is my invention, and the hardware, not so much. I think what I've really added here is the algorithm. You do a patent search and you find out, well, the algorithm's known. What you've done is you do have better hardware in the way it works, and so then you're switching around, right? And so these first steps and the time and the cost and everything else associated with it depends on how concrete let's say this, how unidirectional the process is. If it's going back and forth and looking at doing new searches and coming back and reconsidering what your invention is, well, it's going to take more time and it's going to take more money to get where you want to go. But ultimately you draft an application, and then as we'll talk about later, within a year you need to decide where else other than the United States, assuming you file in the United States first, where else other than the United States you want patent protection. And we'll get into the strategy and choosing that.
Thinking of small companies, if I worked in either an industry or a company that has a lot of patents and so on, then the whole idea of having a patent and looking at the work I'm doing and so on, I can identify and I want to pursue it. But if I've never had a patent before, how does that happen relative to deciding that there's something patentable here that could be of value? I'm thinking small companies.
Yeah. Yeah, I mean, it's what actually motivates somebody to come through
Right,
the door and decide that
right.
they want to do this? Well,
Have you had any experience in that relative
Oh,
to
for sure.
first-timers?
for sure. Yeah.
How does that happen, or, positively?
Well, I think either they see the Chamber of Commerce presenting providing an opportunity to come to a presentation like this, or you encounter it in various kind of ways, right? In a tech journal. I mean, maybe some of you even have an answer to that. If this is the first time you're doing
This
it.
is my first time dealing with any of this. I'm a student over at RIT,
Okay.
and I met Jeff. He came to the university, last semester, I believe.
Right.
I'm working on a project that we got to a point where, hey, we have something here that might be worth protecting. We're working with Eaton Industries and a lot of people who are a lot bigger than us who could possibly take this.
Mm-hmm.
And so we decided, okay, we need to get some more information. And then, I got his email, hey, I'm doing this thing for the Chamber of Commerce. Sign up and take a look. And so information's key. Lots of Google searches. Utilizing whatever resources we have around us. So like the university's great. Obviously RIT is a big university. And then, they introduced us to you, so.
I think the amount that's available on campuses now is just radically different than when I went through engineering school. And I get a skewed view when I step onto the campus of RIT because everybody that comes to me has an idea.
Yeah.
But my general impression is it's way more pervasive now on campus, you know, like everybody has an idea, and there's more courses that require you to have a project where you at least go through the, you know, go through a dry run, which is great.
They're definitely pushing innovation now.
Yeah, oh, for sure. There's buildings dedicated to it. I remember when I went to the University of Buffalo, undergraduate, and they had the incubator, and I just remember vaguely people talking about that building over there, which is outside the main loop, is where they work on ideas that come out of these labs. Like, it was way over there. You couldn't even walk there, you know, like in a reasonable amount of time. But now it's everywhere, and there's classes and clubs and everything else. So that's the way, I mean, I think students coming through now certainly are exposed way more.
Gotcha.
All right, the application process and prosecution. So, application drafting, generally referred to as, or commonly referred to as, application preparation. So you file the application, you prepare the application, you file the application, you wait a year or 2 or 3 to hear from the patent office, right? And then you end up in a back and forth prosecution. So a little bit different. People when they hear prosecution usually think litigation. In this sense, it means prosecuting more in the sense of, you know, for lack of a better example, a war, the way you go about it, right? Prosecuting a battle. So this is prosecuting with the patent office. And then you receive an office action, which is to say the examiner reviews your document and comes back with usually quite a bit of specificity why they don't think you're entitled to a patent, and you need to respond. Either telling them they're wrong in their law, wrong in their facts, or maybe they're right, as I say, and you need to amend what it is, your claims, and amend what it is you're looking for protection, because that's the focus, again, the claims. The examiner reads the rest of it sometimes, but they're really looking at the claims and saying, does this exist somewhere else? And they're specialists in fields. I think in Europe you see, you know, people's careers last longer, and they really are specialists in these fields, and they do quite a good job. In the U.S., you see a lot of that, but I think you see a lot more new folks. You know, you're interacting with a lot more new folks too. And so you end up in this back and forth, and hopefully you get to a point where the examiner thinks your idea is novel, not obvious, and novel. Novel meaning there is no one other document that shows every element of your claim, right? The examiner, that's the game, is the examiner is going to read the element and say, well, here's this, and this piece of prior art, that is everything that was known before you filed your patent application. Next element, yep, I see that. Next element, I see that. All right, I see them all, you're not now. But then there's another standard, and that's obviousness. And obviousness is, well, the examiner isn't going to look at one document, they might look at 2 documents, but they're going to look and say, yeah, you know, you're different than this first document, but this other document teaches you would make that change, you know, whatever it is I couldn't find that was in your claim in this one document, it's shown in this other one. And that other one tells you, the reason you would do this is because it improves X, or something like that, in which case the examiner's going to say, well, one of ordinary skill in the art would know to modify that first document in view of the second document. Right, that's obviousness. And then there's this third standard. How many people here would say they're involved with software in some primary kind of way? Okay, software is kind of it's been in a unique place since 2014, and since I already gave you a bit of the civics lesson, I don't have to go there so much right now. But in 2014, the Supreme Court weighed in a case called Alice Bank, which is not important other than you'll see it in some literature out there. And they really swung that pendulum, you know, as I said, in the 70s, software wasn't patentable. And then we came all the way, you know, it kept, you know, I suppose the thing that always sets me straight is I think back to the 70s and the 80s, and you had, you know, IBM launching their PC, and they said, we're going to make the hardware. Microsoft, you can have the software. That's not worth anything to us. And of course, Microsoft did what they did, and IBM did what they did in the space. But, you know, I think the courts were in the same place. They said software, and then it became clear that any innovating economy was going to require software, and so they said, yeah, okay, we've got to find some way to make this patentable. So you started in the 70s, not patentable, and it went all the way to well, there were various cases that put some limits on it, but you swing all the way to 2014, and pretty much anything was patentable. And the Supreme Court finally stepped in and said, you know what? People are trying to patent basic ideas. They're not even complete solutions to a problem. They're just some underlying idea, and you know, you can think in terms of algorithms, right? It's an algorithm that does this and does this and does this. Doesn't, at the end, you know, solve any particular problem other than the mathematical problem. And the Supreme Court said no. You know, we have this thing called an abstract idea. Abstract ideas are not patentable, nor are mathematical formulas, and there's various other exceptions to what's patentable. And it falls under, I mean, it's not a novelty issue, it's not a non-obvious issue, it's really what's called a usefulness issue, is where the courts hung their hats on this one. Yeah.
I have a couple of clients at least that own small businesses in the optics industry specifically.
Okay.
And they were asking me about, you know, specifically patenting a process, like a manufacturing process. Would that, I guess, what are like the, in terms of a patentable subject matter, because it's like a whole step-by-step, you know, sort of, I don't want to get into too much detail, but is that, how is that different from a physical, I don't know, a tangible item?
Yeah, well, as I said before, an apparatus can be patentable, a method can be
Method,
patentable.
yes,
yeah.
yep.
And those are two distinct things. You don't combine them in any one claim. And so it's steps. If somebody performs those steps, they infringe. Generally, if you can, you want an apparatus claim. It's just easier. And I would question, you know, whoever it is that you're dealing with, is there something about the underlying apparatus that's patentable, and try to go for that too. It's just easier to, you know, finding out who's doing the steps. And frequently it's a wrong person doing the steps. When you think in terms of who it is you want to sue. You want to sue the manufacturer, you know, they're, you know, in one place and you know who they are. Whereas when you get to steps, frequently, one, they can be divided among different people, which can be a problem, right? Everybody does the first 4 steps, or you know, somebody does the first 4, and then somebody does the last 2. And divided infringement can be a nightmare in court for one. It's less easy than, hey, you're making or you're using this patented device. I know who you are, stop, right? I mean,
Right.
it's just cleaner. But it is possible, and sometimes the method is, you know, all you can go at after. And in some instances, it is the more valuable thing. It's just more the exception than the rule. All right, so provisional applications. Everybody heard of provisional patent application? Everybody? People know the term generally. The reason I bring this up here is because people are always of the view, or frequently of the view, you know, we're just going to file a provisional patent application. We don't, you know, we don't have time to file a real one. Well, the important thing to know is, one, it's a 1-year placeholder, right? So you file a provisional application, you have 1 year to file another application, and you claim priority. That is, you identify that application in your follow-on application to get the benefit of your earlier date. Yes?
Does that have an approval?
No examination process. It just goes
No
down, you put a
examination
cover sheet on whatever it is that you've prepared, you send it down to the patent office, and they hold on to it, nothing happens, and nobody cares about it, other than, what's it?
But you have to have the details behind it?
Well, that's exactly what I'm gonna get to, and that's the key here, is, you can submit with the patent office, give them the cover sheet, give them the money, and give them the documents, and they'll take it, and fine, and nothing will happen. 1 year from then, within 1 year, you need to file a non-provisional application. But the important thing to know is they're the same requirements, ultimately. You need to teach somebody to make and use the invention, it needs to be fully described. And that, you know, the ultimate question is, did the disclosure in the provisional application support, that is, was it all fully described, or let me say it this way, did the provisional application fully describe whatever it is that your claims are that ultimately get issued? Realizing, as we said, you know, you file your application, you may have some back and forths with the patent office where you amend your claims before you can get the examiner to sign on, and then you get your issued patent. Here it is. Is that provisional date worth anything? Well, yeah, if everything was described. You know, it's fully
It
supported in the
seems
earlier
like- it
one, and
seems
if it
like you're-
doesn't, that earlier date's worth nothing, and you're stuck with the later filing date anyway.
Well, it seems like you're also giving away your idea, you know, in
How so?
Huh?
How so?
Well, I mean, you're describing,
Exactly.
you're describing your idea,
You have to, yeah.
yeah, and if for some reason, so it becomes public,
Right?
you
It's
know.
published,
It will get published after
Yeah.
18 months from the non-provisional filing. A provisional application does not get published.
Oh, it does.
Oh,
Let me correct this. It's 18 months from the original, the priority date, the provisional date, but the publication itself is of the non-provisional filing,
Okay.
right? It's the non-provisional filing gets published
Yeah, but
18 months from the earliest priority date.
You do somewhat run a risk, though, because if you can't get it all done in a year,
Well, that's my point exactly, though, is there's no get it all done. I mean, it needs to be complete. The same requirements of using full disclosure apply to a provisional application. What doesn't apply is formalities. You don't need to have all, you don't need to have formal figures, you don't, it just, you don't necessarily have to organize it, right? You just submit whatever it is. In some instances, universities are notorious for this. They submit something that's been a publication. And a publication isn't a legal document. And the problem gets to be, when you file the provisional application, haven't contemplated what your ultimate claims might be or what some of the fallback positions are, you can be surprised. I left out something that I really should have put in there. And so you need to think about claims. Although claims aren't a requirement of a provisional application, if you don't think about them, you might be surprised in the end. And so, there's various strategies which I won't get into because I want to make sure we get through all our slides here. But to just have people just say, oh, we'll just file a provisional, we'll deal with it later. That works to a degree, but you're dealing with risk. Sometimes it's the right thing. Sometimes it's a matter of funding for a small company. Like, I don't have funding right now, but a year from now I will. So I need to file a provisional and I need to file it low cost. But the important thing is my job is to say, you need to understand there's risk associated with that because you aren't doing a full review, you're cutting corners, and when you get to the end, you might be surprised that you don't have full support, in which case that date's gone. Which can be important to say, one of the reasons you want to file is because you're going to have public disclosure, right? You're going to disclose in some kind of way. So I file provisional, disclosure happens. Now on the other side, I file the non-provisional, so the disclosure was before my non-provisional. And now I get over here and I find out my provisional didn't fully support my ultimate idea, my ultimate claimed idea. I'm stuck with a later date. In the US, you have some leeway there, but other countries don't allow it. So you can shoot yourself in the foot thinking you've got patent protection when you don't. That's the concern with provisional applications.
what's it cost to do it?
Well, depends, right?
Oh, okay.
Depends what the invention is. And as I say, it depends on the individual circumstance, but you want to be as complete as you can be. And in some instances, a provisional application isn't all that much less expensive.
I was thinking of the patent office fee.
Oh, well, responding to an office action, again, that can vary too, depending on what it takes to respond and how many rejections there are and such. So, just give you an idea of costs, initial filing, round numbers, you're thinking about $10,000. And that's, 3 components. Attorney time is the biggest one, government fees, well, there's one price that IBM and GE and any company that has more than 500 employees pay, and then you could pay half if you're a small entity, and now there's a micro entity, which is a half again. But that's kind of in the noise, really, when you're talking $2,000, $1,000, $500 versus, the bigger portion, $7,000 or something like that, attorney's fees. Draftsman, less than $1,000, and if you want to, you could probably do your own.
Is there any place for people to do it cheaper than that relative to associations or whatever?
You can always find somebody that does it
Okay.
cheaper. Yeah.
For example, legal cost, if I want to do an LLC or something like that,
Yeah.
everybody says, we'll go to LegalZoom.
Oh, I mean, yeah, they'll give you,
So
they'll give you a
you
form,
can do
and
the
you can
same
go
thing
by
with-
yourself and file an application, but, there's a lot of things to get through that you.
I understand the
I can
risk
tell
I'm
you,
taking,
do not
Yeah.
skip out on
but
Yeah, sure.
people do it.
Yep. So the important thing is, you want the attorney and the inventor to work together to get it done. That's the way you're going to get the best product. Whether to seek patent protection, what rights are protected, you need to think in terms of what it is you're going to get from the ultimate patent and what it is that you're going to be keeping other people from doing. And there's a variety of reasons. You could do it for the pure competitive advantage of it, right? I mean, that's the way to think of a patent, is competitive advantage. But also people will do it because of funding, right? Like, I don't think this is patentable, but I know that when I go for funding, they're going to ask me, do I have a patent if I file the patent application? Marketing, sometimes it helps with, it's a marketing issue. Sometimes it's negotiating, right? If you're negotiating with a company and you want to provide them the product and you're the patent holder, they realize, hey, if I work with somebody else, there's a risk that when I get to the end, I'm not going to be able to do this, I'm not going to be able to work with them or get product from them anyway. So factors on the positive side, all of those things all ultimately boil down to exclusivity, right? Whether it's the funding source that's thinking, hey, they're going to be the exclusive producer of this, so I want to fund them and that's how I'm going to make my money. It may not be the inventor that's necessarily thinking that way, at least at the outset, but somewhere somebody's thinking in terms of a patent provides exclusivity. And then you have to weigh against that the expense for a startup. Frequently that's, do I want to spend more money developing? Do I want to spend more money marketing? Do I want to spend more money on travel? And you've got to figure that all out, right? You've got to make it all work. Of course, it becomes public, like we said, with publication. It takes time to obtain, and ultimately a patent after 20 years expires, and it becomes public domain. You have a limited time to decide, right? You've got competitors who might, if it's a very competitive space, they might come up with the idea and file before you. And then you've got to be careful of your own public disclosures, right? If you've got the idea out there and you've made it public, it could be your own work and your own publications that keep, that put the time limit. Once you've published it, in the US, you've got 1 year to file a patent application. In Europe and many other countries, once you've made the idea public, your rights are gone. Considerations. Ultimately, you want to focus on whether what you've claimed is something that your competitors will want to do, right? The focus is on what value it provides to your competitors to do what you've claimed. The focus is not you and your product. And in some instances, people will come to me and say, here's a great invention. This is my idea, and this is why it makes my product better. Okay, you solved a problem. You solved a problem that you had in your product. How about when the competitors come out with their product? Are they going to encounter the same problem? Well, no, they do it differently. Well, okay, it might be the greatest idea for your product, and it might make you competitive, but it's probably not something you want to get patent protection on. You got to think in terms of what's the likelihood of success. So we're thinking about whether we want to file. What's the likelihood of success? And there has to be in there somehow, some kind of measure. And you need to understand whether you're likely to get a patent or not. And then there's context, right? A lot of it depends on what the nature of the product is. I've worked with Bausch & Lomb, worked on surgical counsels, hundreds of thousands of dollars to buy the counsel. There's some great innovation in it. There's multiple players in that space that provide some kind of, some kind of competitive product. But there's disposables in there, right? Just more widgety kind of things. And those are the things that are that recurring cash flow that are really the value to the company. But it's a bag. It's a package of some kind. Like, how are we going to get some kind of patent on this? Because what happens is you sell this large product, this capital equipment, to the hospital. They spend a bunch of money on it, and then they're looking to replace the individual things that go into somebody's body or the things that collect fluid or whatnot, right? And those are the things that keep getting sold month after month, and the company's really interested in. So then the question becomes not how do I protect the surgical counsel? There's other forms of competition that deal with that. It's how do I get the business of, the exclusive business of providing them those disposable products? Because there'll be cottage industries. They'll never make the Counsel. They just want to sell the bag or the probe or the whatever. So very, kind of very interesting, very different mindset when you end up in that kind of predicament. Further considerations, did you realize when you file a patent application, the publishers, your competitors will be looking at it and they'll know. And it will potentially create doubt and uncertainty. Like, I really want to get involved in this if they're going to get a patent on this. How much effort do I want to put into this, knowing that, a year or less or more down the road, they're going to end up with a patent. So the very presence of a patent application can affect competitor behavior. And the important thing to know is that, as I said, there's the uncertainty aspect, not black and white. But patents look different to different people. And this is, when I talk about context, this is an important thing. A small company, if they're going to run into a patent, it may as well be, a wall 100 feet high and miles wide. They're not going past it. They're not going to challenge it. The last thing they want to do is be sued. Whereas, if you're Behemoth Company and Behemoth Company and you each have portfolios and I see you have a patent, maybe I'm thinking, well, yeah, you infringe my patent, I infringe your patent, we'll figure a way around this. So patents start to look very different. Or I think in terms of, there's ways to challenge patents that might be open to a company with more resources, right? So they can challenge a patent down the road, either in the patent office or in the courts. So, a patent infringement lawsuit can cost millions of dollars. But you ask yourself then, why as a startup, or why as a small company would I ever get a patent? I'm not going to spend $1 million. It's because it's an asset. And if you aren't going to capture that value at the outset, the value of being able to potentially sue somebody and have exclusivity, if you're going to capture that at the outset, you've foregone it, right? Once your idea gets out in the public, there is no more option of patenting it. So if you're going to capture the value of your inventive efforts, and maybe capture the value within your company if you're going to sell your company or do something else, like maybe license the idea. If you aren't going to capture the value of your inventive efforts in the form of a patent, you're just throwing it open to the public. Whoever can do it, whoever wants to do it would be able to do it, and you would gain no benefit from your own innovation. Even if you got to the point where we'd sue these guys, they're clearly infringing. They're making these products, so there's plenty of damages to be had if there is a lawsuit, but I don't have $1 million to start this lawsuit. You'll find a partner, you'll find somebody who'll see the value in what you're doing, and because you have the patent, you'll have ways to trade and capture the value of your asset, and a way to enforce your patent. Right? But it is get it or forget it. So pre-filing, post-filing. Pre-filing, public disclosures your enemy, right? Your own disclosures can keep you from ultimately getting a patent. Commingling, going to somebody and talking to them about problems you're facing and coming up with a solution, and you're collaborating. They may be inventors on your patent. You got to be careful about that, right? There's a place for different kinds of agreements, which we'll get into next week, that deal with this issue. Post-filing, well, any rights you have once you file the application are fixed. You don't know what they are. You might get a patent, you might not. It might be broad, it might be narrow. But any rights you do have are fixed. The prior art, it's out there. You might not know it all yet, but nothing changes. It's your choice whether you want to go out there after you file and talk to somebody. The one thing is, it's secret for 18 months, but you need to decide on the value of that secrecy. Right? If you want to go out there and talk to somebody, they say your rights are fixed. If you start talking to them, you've identified problems. It might start them thinking, and they're going to patent things. But it's a business decision to be made, whether that secrecy is worth it, or whether the going out and talking to somebody is worth more. So, trade secret. What is a trade secret? There's the definition. It's broader than what's patentable, right? Formulas, patents, compilations, recipes. Like we were talking before, some things overlap with patents. And then here's the two keys. Derives independent economic value, actual potential, from not being generally known. and not being readily ascertainable. Is subject of efforts that are reasonable under the circumstances to maintain secrecy. So, you need to establish that you have a trade secret before you can say, hey, you were under an obligation, employee or contractor who came into my facility or whoever, and you had some kind of obligation in the form of a non-disclosure agreement or confidentiality agreement of some sort, and now you've got out there and you've disclosed my idea to a competitor, and the court, you can go into court with this idea, and it's, I mean, they're in the news quite a bit now.
Now, can that be processed again?
Oh, yeah.
Can it?
Oh, for sure.
Doesn't have to be.
Yeah, it's actually
Oh,
much
it's still
broader.
processed.
It could even be, it could be lists of customers, right, which would never be a patentable thing.
Yeah.
So, how do you maintain a trade secret? The court's gonna look at whether you treated it as a secret, as things we were talking about before. How much you certainly had to limit access from people outside unless they're under some kind of agreement. You have to limit access internally to a need-to-know basis, or at least ideally you are. You have some kind of policy. You have people signing agreements, acknowledging, hey, I've been exposed to this trade secret. It is the trade secret of the company. You're not going to disclose it. Well, once you've done those things, it used to be very much a state issue, but the federal feds have gotten involved. And not to pick on any individual group, but the Chinese government in particular, who have been in the news plenty. As a matter of fact, I think just yesterday there was the Department of Justice filed a lawsuit against Huawei for stealing, who is it? Not Verizon, one of them, not Verizon, one of the big telecom companies, trade secrets. And so it's becoming more and more a federal issue, a criminal issue. Criminal is not a part of patent. It is in some countries, it's not in the US. But trade secrets, yeah. It can be civil, so an individual company can bring it, but also it can be criminal. We talked a bit about that. Can you detect? So in making a decision whether to file a patent application or to treat something as a trade secret, it's going to depend on the nature of what it is you're trying to protect. So we said trade secrets can last forever, but a patent's more absolute. Industries like the oil industry or the petroleum industry, where you've got a bunch of processing going on behind the scenes, tend to do a lot of trade secret work, right? Why would I ever put in a patent exactly what I'm doing when whoever else it is that's doing it's going to be doing it behind closed doors? I don't know if they're practicing my invention. If I had a patent, it would be tough for me to even know there was an infringement. So you got to think perhaps trade secret's the more appropriate thing rather than putting all of the information in a patent application and teaching everybody. And well, we already talked about what's going to weigh into it. It's going to be patent. Where to seek protection, where is your market, where are your competitors, where is the invention practice. Those items we listed before that are infringement, making, using, selling, offering to sell, well, it has to be done within the borders of the country that you're seeking protection. There are treaties that involve patent applications. The whole reason you can file a first application in the United States and wait a year to file elsewhere is because the Paris Convention, fairly old treaty, and then now there's the Patent Cooperation Treaty, which means after 1 year you can file one application that will then preserve your rights in other countries, and you can wait. There's actually an early examination. It's not binding on anybody, but you get an examiner to look at it. You can choose which country you want to do this, and they'll give you an examination report, which will give you usually it's your first insight into patentability. It's not binding, but at least you've had an examiner look at it. No rights are granted, as I say. Granted, it's not binding. So it's usually file a U.S. application, file elsewhere within a year, and then 30 months later you file national stage, and you need to be in every country. You need to make your final determination which countries you're going to be in. But now at least you've had a chance to see some kind of examination. You might even have heard from the U.S. before 30 months are up. So you'll have some insight, and you'll delay costs, the government costs with filing, the attorney's fees, because you need attorneys around the world, and translation costs are also a big deal in many instances. So you have just a cost timeline. Big cost right there, it's kind of lumpy, right, the costs. Initial filing, foreign filing is going to be expensive, and then once you end up in the individual countries, frequently they require yearly payments of several $100s to keep your application going. So you've already talked about that a bit. Oops. Design applications. So design applications are about ornamentation. They're not about utility. It's how something looks. And I'm not going to spend much time on that. But in some instances, this can be valuable. And it can be an add-on. You can do both. You look at you patent the way things look. The application here is not words as it is in a regular application, it's figures. All right, so quick summary, what you should come away with here. A patent is a right to exclude, right? It's not a right to use. Very important, very fundamental idea. Claims are the key. You got to take time, you got to think about it, and that's why with provisional applications, to go into the whole process and not have a claim strategy in mind in some form, it's really questionable. And the focus always is on what others will want to do. How much value, how much competitive advantage do you have if somebody can't practice what you've claimed? Claims cover inventions, not products. That's something that people struggle with. They kind of become synonymous in their mind, product and the patent, and that's not true. Right? This is claims, and an invention is much more abstract than a product. Patents aren't black and white. You need to deal with risk. Until filing, public disclosure is your enemy, and you need to think about at least commingling when you're meeting with people. Josh, being somebody who's on campus and having dealt with plenty of people in that setting, it's really has issues with commingling. It's like, I talked to my dorm mate who's really smart about this, and we were working on this. Like, well, you don't have a company form yet, and they haven't assigned any rights to you, so if you file a patent application of what you're doing, you may need to name them as an inventor, and they have no obligation to you. Right? So there you've got somebody else who may have rights in your idea. And that happens in other contexts in industry also. Round numbers, just a number to keep in mind, $10,000, give or take. There's, of course, a range around that. Trade secrets require active management, right? It can't be that colloquial, hey, it's our trade secret. You need a policy. That's it.
That word commingling,
Yeah.
why don't you use the word disclosure? Commingling, I almost think of a chemical process of throwing some stuff in a big pot.
Well, that's what I mean. I don't mean disclosure, because it doesn't have to be a disclosure to the wide world. It has to, what the concern is, am I going to put myself in a predicament where there's going to be inventive activity, and it involves somebody who has no obligation to assign the invention to me. So it's commingling. I'm giving somebody else essentially rights to whatever it is that I might have wanted exclusive rights to. All right.
A question that